everyone. I'm Dylan Greenwood.
And I'm Harold Eustache.
And this is For the Record with Greenwood Law. We're here today to talk about another important issue facing North Carolina. And we really try to do that here on our show, but this is one that actually could affect more people than anything we've ever talked about. And it's about expunctions or expungements. And for those of you who may not know what that is, that's the process, the legal process of cleaning a record. So let's say you got criminal charges at some point. There are different ways in which those could be taken off of a record so that anyone looking at your prior criminal history, whether for a background check or what have you, would not be able to see that. And North Carolina has expanded how those expunctions can take place, hasn't it, Harold?
The legislature's passed a new law called the Second Chance Act, where they've made expunctions more available to all North Carolinians. And part of the rationale for it was that it's very difficult with a criminal record for people sometimes to find employment, maybe to find housing and other things. So the legislature wanted to make it easier for people to clean their record up, because about 1 in 4 North Carolinians has a criminal record.
And I think if you do the math on that, that's a potential for over 2 million North Carolinians that could be affected by this act in some way. Now, it doesn't mean that all of those 1 in 4 are automatically eligible at all. There are actually some very stringent requirements. Now, that is eased up, but I think when it gets down to it, you got to meet a certain few key things. But employment isn't the only reason why people contact our office looking to try to clean their record, is it?
No, it's not. I mean, sometimes people are falsely accused of crimes. One thing we see sometimes is people will unfortunately have relatives or people close to them borrow their identity, and sometimes they won't even know that there's a criminal conviction or charge on their record, and unfortunately they'll find out when the background check is done, and they'll need to get that off their record. And sometimes people just don't want the embarrassment of having that charge or conviction on their record, and they want to get rid of it. So there's lots of reasons for it, and even some of these convictions, not just when you're applying for just any job, a regular job, but there's also certain types of licenses in North Carolina, such as barbers or other types of licenses, that can be affected by having a criminal conviction. So again, it's very important for many North Carolinians to expunge their record.
Because really the most common scenario that we see is we get called. Someone's talking to us and they say, I need my record clean.
Mm-hmm.
I thought when I went through this 5, 10, 15 years ago, I got a dismissal or I was found not guilty. And they go, well, I thought it was just off of there. I thought it was gone. And they're surprised when they either try to apply for another job, they're up for a promotion. Sometimes we get it when people do contracting work, especially with the government, because they'll do background checks on each new job. And we've gotten plenty of people that have called us up that's, I've been able to do everything with this job, and now we took this extra one with the government, and they run this background check, and they're telling me I can't be on the job site because I have this thing that's on my record. And we see that so much because just because the case was dismissed, you were found not guilty, or what have you, I know for a fact we've come across HR departments that will pull someone's background and not be able to fully understand the record that they're reading.
A lot of times, if somebody is arrested and charged with, for example, misdemeanor larceny 10 years ago, and let's say that charge was dismissed with a deferred dismissal, that's sort of a technical thing that we deal with in the court system, but an employer may not understand that language at all and may just see misdemeanor larceny. And even though that charge was dismissed, they still hold that against that applicant. And so that's part of why these expungements are so important, because it really does expand the ability for a lot of North Carolinians to work, because there's evidence that that people, when they expunge their record, their incomes actually increase.
Up to 25%.
Right.
In some cases. That's just the average.
Right.
And when these people do background checks and they see just something listed, even though it may have been dismissed, and the people, when they just get this printout report, whether it's through HR or whoever's doing the background, they don't know why it was dismissed. They don't know how it was dismissed. Sometimes they don't even know how to read that it was, in fact, a dismissal or not guilty. A lot of people, and we've talked to and educated a lot of people, that just because something is listed does not mean that that person was convicted.
Right.
Yes, they were charged, but it doesn't mean they were convicted. But then the follow-up is, and this is the unfortunate thing, is, well, they were charged. They should have never been charged in the first place. They never should have put themselves in a position to be charged in the first place. And Lord knows, you and I see stuff every day where that's not a fair assessment of what happens.
Right. I mean, people come by getting charged with crimes a myriad of ways, and sometimes, like, again, it could be, identity theft, or it could be a million other ways. But a charge simply brings that criminal offense, potential criminal offense, to court. It's just a mechanism to bring that to the justice system, but it doesn't mean that that person is necessarily guilty. Of course, we have in our system that people that are charged with crimes are, of course, innocent until they're proven beyond a reasonable doubt guilty, and that's part of the rub, and that's why the legislature's done some of this. So, when they pass this Second Chance Act, what are some of the changes that happen or that are going to happen in the future with this new law?
Well, it's an incremental change, and there are going to be some changes that happen immediately this year, and then there are going to be some changes. The most significant change, I would argue, would be December of next year, December of 2021. Okay. And the major thing in this bill is basically what we get called about, is that if you get a dismissal, a not guilty, basically anything other than a guilty on your record for the charge, North Carolina has said that is going to be automatically removed from your record starting December of 2021. And that is a huge impact on a lot of people.
It really is.
And I understand why the legislature did it. Because when you parse out the numbers on it, and you say, well, okay, let's get these people in a situation where they can work again, or where you not have one of these barriers to an opportunity to work, and you juxtapose that with what it costs to put someone in prison. The average prison bed in North Carolina per year is over $36,000. But you could have somebody out there working, and then they come back. Well, what happens when you work, Harold?
You pay taxes into the system.
You pay taxes.
Right.
So instead of a cost that you're putting out on somebody, you're getting revenue for the state back in because they're actually working. Because it's something, when people have these barriers to entry, it's something like 41% on average get arrested within 2 years again. Right.
Because it's that cycle that happens over and that we see all the time, where somebody can't get a job and then they're caught in this, trying to make income some other way.
It is a vicious cycle.
It really is. So let's say somebody had a plea deal, which we see a lot, after in next year, and some of those charges, let's say they had some felonies and they were dismissed. Would that automatically be expunged as well?
Yes. So it would, because another major aspect of the law is that having a prior felony on your record doesn't bar you necessarily from getting an expunction. So that's one of the biggest things we run into now. In fact, it's unbelievable how far we've come since I've started my legal career. When I first started, you got one expunction for your whole entire life.
Right, I remember that.
And that as a fledgling DA.
I remember that. That was like, I remember.
Yeah. What would happen was, this was the classic scenario, is that someone would be in a relationship that they probably shouldn't be in, and their significant other would want to work through all the issues of the relationship through the court system. And they would rack up all these communicating threat, assault charges, and then the person wouldn't show up to court. They didn't want to follow through with it. They thought better of it, whatever. Right. And they would have like 8, 9, 10 of these listed. And they would come to you and say, well, I want to get this off of my record. And you go, well, pick one. You only get to pick one. And that's the one that's going to be taken off. And they go, well, what good does that do me? And you're on the other side going, well, I know.
Right.
It's a drop in the bucket compared to the situation that you're in. Fortunately, though, shortly into my career, that law changed, where you could get unlimited expunctions for dismissals and not guilties. But it came with a caveat, and that caveat was that you couldn't have a prior felony on your record. So, I know of a case that I had last year where a guy had a prior felony, had done his whole entire time, had really changed his life, and picked up a really low-level marijuana charge. And he had never really been involved in drugs, no nothing. Mm-hmm. So he was eligible for some particular forms of relief. Mm-hmm. And he said, well, I want to expunge this because, all of a sudden he was a driver and some other stuff, and he's like, I don't want this to mess up my opportunity. Because people are going to see this, because he was running to the same stuff that we're talking about. Now, under this law, that person that we represented is going to be eligible to have their record expunged, when just a few months ago, when we wrapped the case up, he wasn't. So
that's huge for that person's life.
Yeah,
for sure. Another thing too is that there's a period of time that people have to wait if they are convicted. So I know we've talked a little bit about expunging things that have been dismissed and not guilty, but my understanding is that there's a way to expunge things that for people that do have convictions.
That's exactly right. And I guess it's almost 5 years ago at this point, that became a new thing in North Carolina, where you could get a non-violent misdemeanor or felony expunged if it was the only thing that you had ever been convicted of, except for like traffic offenses and stuff like that. And the legislature really narrowly defined what non-violent versus violent misdemeanor and felony was, and they really haven't touched that. So that is still there. And I mean, the violent misdemeanors and felonies still can't be expunged. Not at all. So if there's something that has assaultive elements to it, mm-hmm. So think things like simple assault on a female, sexual battery, mm-hmm. Any of those types of things, assault on a government official, no way. The only way you can get that expunged is if you get a not guilty at trial or it was dismissed in some way.
Okay.
And the legislature goes even further than that and says, well, you also can't expunge anything between an A and a G felony. You can't expunge anything that has breaking and entering as a part of the elements, because breaking and entering is considered to be violent. Mm-hmm. Even when in federal law, it's considered to be violent.
Right. And
that's something that can have implications there. Anything where you have to register as a sex offender, can't get it expunged unless you get a not guilty or dismissal in some way. So, I mean, there are a number of things that are really barred from being eligible. But if you are eligible and you wait a certain period of time, then you can go down the expunction process. That process is much more involved than anything involving just a dismissal. And a dismissal or a not guilty expunction, as you know, Harold, is very straightforward. It's one piece of paper and some appearances in front of a judge. When you start looking at expunction where you've had a prior conviction, all of a sudden you've got to get affidavits from multiple people talking about your good character. You have to wait that requisite period of time. You have to then petition and file stuff with the clerk, the DA's office, judge's office. You have to have a hearing on it.
Because the DA would have the ability to make an argument against that person having an expunction.
And 99% of the time, the DA doesn't have a dog in that fight. But you do have the one every now and then where they will come back and argue. And I've seen that. And it's always interesting for whatever reason when that does happen. But that's why it's important to have an attorney in those particular types of expunctions. Really, it's important to have an attorney in any type of expunction because of the way you need to get judges to sign stuff, the way you have to petition and do all that. But especially with this type, where you've had a prior conviction.
And I've seen it in court where an expunction is on the docket, and the person is doing that expunction pro se by themselves without an attorney. And a lot of times, these expunctions can be kind of technical in the paperwork, and if you mess something up, the judge won't sign it. So it is important to get counsel on these.
If you're just joining us here on WTOB, for the record with Greenwood Law, got Dylan Greenwood, myself, Harold Eustache, here talking about North Carolina's expanded Second Chance Act. And it's an act that could have a huge impact on many citizens here in North Carolina for being able to clear up people's criminal records that could have huge, significant impacts on job opportunities and just avoiding a lot of embarrassment for some people, and just being able to go through life knowing that your record's clear and that maybe one mistake in your life doesn't have to define it. And that's a philosophy that we really hold dear here in our office, that we don't feel like one mistake should have to define someone's life. And we've been talking about all of these ways in which people with prior convictions can get expunctions now under this new act. And so there are a few ways in which that can happen. So there are expunctions for one misdemeanor conviction. There are expunctions for multiple misdemeanor convictions. And then there's an expunction for a singular felony. And the way in which all of these can interact is really technical. It is significant. The way the legislature has set it up, it really, if there are multiple convictions that could potentially be eligible under all of this, it is very important with the timing of each individual expunction. But fortunately, anyone who's going down that road should have time to prepare for that, because there is a waiting period.
Okay.
And that waiting period comes when, depending upon the type of expunction. So if it's a one-off misdemeanor, the waiting period is 5 years. If there are multiple misdemeanor convictions, the waiting period is 7 years. And if it's a one-off felony conviction, nonviolent felony conviction, that waiting period is 10 years. And when you look at each individual one of those, the time period begins essentially from when whatever the punishment was ends.
So if I was convicted, a defendant was convicted of, obtaining property by false pretense, which would be less than a Class G, so it would be eligible for expunction, and I had 24 months probation. I would have to wait that 24 months, finish my probation, and that
the
would
clock
be when
starts then.
Okay.
Yes. So at the end of that 24 months, that's when you start the clock for 10 years. So go ahead and set the reminder on your phone. 10 years from then.
I keep my phone that long.
Yeah. I know you do. So go ahead and set that reminder, and then call up whoever you want to represent you and get it done. Again, because these are so technical, and everything that you have to file, if you mess it up, then you're not going to get your expunction. Court isn't going to grant it.
Right.
So it's really important to get it right. And Harold, you've had a lot of experience when it comes to juvenile issues. And there are significant rules and laws and stuff that affect juvenile expunctions, because one of the things we get talked about, again in the same vein where people don't realize it's on the record, is everybody just assumes that if it happened before they were the age of 18, then no one's going to know about it because they were a minor.
Right. And part of what happened in North Carolina is we had this change in the juvenile law where we raised the age from 16 to 18. So because the age of juveniles has been raised, what the legislature tried to do to account for that was say that if you were convicted of a crime between the ages of 16 and 18, and even if that crime was prior to December 1st of 2019, you can potentially get it expunged. And you'd be eligible, if it's a nonviolent crime, or it also cannot be a DWI, and you finished all of your probation, paid all your fines and fees and all that sort of stuff. It says that the court shall grant your petition to have that expunged off your record. So essentially what the legislature has tried to do was the same way that if you were in juvenile court after December 1st of 2019 and you had a conviction and it wouldn't go on your adult record, what they've tried to do is sort of retroactively make it possible for people that are convicted of offenses between the ages of 16 and 18 to have that wiped from their record. And it's really important because, a lot of people in high school and at that age, they get in trouble for something, and that can follow them quite a long way, and it can also have implications on things like student loans and all sorts of other stuff that's really important. So it's potentially very important for people to get that stuff wiped off their record. So if that is something that you do have on your record, it'd be wise for you to come in and talk to us about that to see how we can help you.
And that's the types of expunctions we've discussed today. They're not the only ones that are out there. There's actually a whole list of potential expunctions.
There are.
It's just, I think if you go through the statistics that the Office of the Court keep track of when it comes to expunctions, they're not used a lot. The most common one is the dismissal or the not guilty expunction. That is used thousands of times throughout the year in the state of North Carolina. Some of these other ones, though, you look at the statistics, and some of them are less than 100, or they're used hundreds of times. So those would include gang offenses under the age of 18, but with that one, there's a 2-year waiting period.
Okay.
Then there are, if you have a drug dismissal under the age of 22, that is one that you can also file for. Now, with a lot of the change in laws that we've had because of the revised Second Chance Act, I think that one, I don't see how it's going to be applied as much anymore. In fact, I think it was probably already on its last leg, just based off of some of the other changes I've seen in my career with being able to expunge dismissals just kind of all over the place anyway. But there are also certain expunctions for prostitution offenses. Identity theft is one. If you're pardoned, I mean, they're all over the place what you can do. But really, when it gets down to it, it's important, if you're eligible, to clean up that record. That way you can avoid any type of embarrassment. You can maximize those job opportunities, get in a situation where you're not affecting student loans and any kind of educational opportunity.
So, Dylan, we've talked about all these different ways to get expunctions. How many expunctions can somebody get?
That's loaded. That is a loaded question. It depends on what it is, the type of expunction, all of that. So what's changed now is that starting this December, if you got a dismissal, a not guilty, it's unlimited expunctions for the rest of your life, regardless of whether or not you're a convicted felon or not. And that's a huge change because, again, that's unlimited. And that's fair, because if you're a not guilty or a dismissal, that shouldn't have to follow you. If you're looking at something where it's a different section of the law where you do have a prior conviction, then that's where it gets tricky. So if you have multiple convictions on your record, there could be an avenue for all of those to be expunged depending upon what they are, even if it wasn't within the same occurrence or the same session of court. That used to be the requirement. That had to all get taken care of at once. And that was a strategy that we would employ
Mm-hmm.
if we knew something was going down that route. But that's different now. Basically, on this change of law, once you start down the road of doing a Section 145 expunction, and so what I mean by that are these expunctions that involve convictions, that's under Section 145 of this statute, then that is your cutoff. Anything that was eligible under that section up until that point, you can work it strategically, maneuver it, try to expunge it. If you're
But once
eligible.
you get it expunged under 145, you have to.
For the rest of your life, you're not allowed to use that section of the law to expunge something off of your record.
Okay.
So let's say you had 5 prior convictions that somehow or another got eligible under this change in law, their Second Chance Act. You got them done, and then you turned around a week later and stole something from Walmart, and all of a sudden you're facing this new charge. If you got convicted, you can't turn around again in 5 years or in 7 years under whichever part of the statute you want to go under and say, well, I want to get a new expunction. No can do. The only way you could get an expunction is if you were to get a not guilty or to get a dismissal in some way.
Okay.
So it really limits your options. So whenever you do this, you better know that your possibility of criminal enterprise is no longer there. That you're on the straight and narrow from then on out, because you're not going to be afforded a lot of these other opportunities.
Glad that we got to talk about expunctions and all the intricacies of that, and how we can potentially clean up North Carolinians' records. Don't forget to join us next Sunday at 10:30 a.m. on WTOB for the record with Greenwood Law. We are going to be talking about gun rights and gun laws. We're doing a 2-part series on that. So next week we're going to be talking about concealed carry permits and all the rights and laws around it, how you get it, and how there are different criminal offenses that could go along with concealing a weapon or a gun. And we're going to talk through every piece of that. And so we hope that you can join us next week on that.
And before we go, as always, everyone, remember the Greenwood Law Bill of Rights. And that's first and foremost, I will not represent myself in court. Second, I will not do law enforcement's job for them. 3, I will not make statements when stopped by law enforcement. 4, I will not consent to searches when asked by law enforcement. And 5, most importantly, I will not be my own star witness for the prosecution. A lot of changes out there when it comes to expunctions, ladies and gentlemen. Could have a big impact on a lot of North Carolinians, getting them back into the job force, productive, especially in the midst of everything that's going on this year in 2020. So it's not a crime to know your rights. Stay informed, stay safe. This is For the Record with Greenwood Law, signing off.